Hi, I'm Manny Fitzsimmons. I'm your Washington REALTORS legal hotline lawyer. Welcome back to our video series entitled DB's Wishlist.
Good afternoon, Ken Sachs here with Keller Williams, Spokane. And my question is related to Form 22EF, the evidence of funds addendum. And wouldn't it be prudent for a listing agent to use the 22EF when a buyer is representing that they have non-contingent funds as a down payment in order to close the transaction? Because so often we see buyer brokers making the mistake of representing their buyer has non-contingent funds when those funds are really contingent. And if the listing agent is not going to use that addendum, at least have in material communications evidence that they've had that conversation with the seller around using 22EF and why. And if the listing agent never does that, could then the listing agent be accused of not representing their seller to the standard and care of an attorney? Thank you so much.
Thanks for this question. It's a question that requires listing brokers to analyze whether or not they are providing the services that a seller needs from that listing broker, whether the seller knows that they need that service or not. This question goes to the heart of what a listing broker can do to help a seller ensure that the buyer the seller selects is going to be able to close the transaction. It does seller absolutely no good to reach mutual acceptance with a buyer who's fulfilling all of the seller's requested terms, paying a phenomenal purchase price, if that buyer can't close the transaction. And one reason why buyers often can't close a transaction is because they don't have the money necessary for their down payment and their closing costs. And they haven't explained that to seller up front because the buyer is counting on some contingent source of funds, like a gift from a family member, relative, like the sale of some personal or real property prior to the closing, an inheritance. Lots of buyers are waiting on an inheritance in order to close a transaction. And so buyer will make an offer explaining to seller that they have to get a loan. They'll include a Form 22A financing contingency, for example. And let's say that they're buying a $400,000 house and they've included a Form 22A saying they're going to put 20% down on a conventional loan. That means that buyer has to bring 20% of the purchase price plus buyer's closing costs, unless buyers ask seller to pay them, to the closing table to close the transaction, in addition to the conventional loan proceeds that buyer's hopeful their lender will provide. But if buyer doesn't have that 20% down plus closing costs at the time they enter the purchase and sale agreement with seller, then isn't seller taking a risk by selling to that buyer, hoping that buyer will come up with those funds? And the point of the question is, listing brokers, isn't it your job to make sure that if a seller ever takes that risk on a buyer, seller does it with their eyes wide open? Because here's what happens way too often. Sellers accept that offer that we just described, 20% down on a conventional loan. And buyer seems to be well qualified. They've got some sort of a wonderful pre-approval letter from a lender, and it's a quality lender. And we get all the way to the closing table, only to find that lender would have funded the loan had the buyer actually been in possession of 20% down plus the closing costs. But buyer's not in possession of that because buyer was waiting on gift funds that didn't come in, or an inheritance on an estate that didn't close in time, or whatever the answer might be. So the question is asking, what should a listing broker, a competent listing broker, do to avoid seller ever being in that position? We can't help it if a buyer doesn't get the loan that the lender said they were pre-approved for, or anything else. But listing brokers, you can absolutely help your seller to be certain that a buyer has the cash resources they claim to have. Remember that Form 21 paragraph A has boilerplate language that says that buyer is not relying on a contingent source of funds unless otherwise disclosed in this purchase and sale agreement. So if buyer hasn't disclosed that they're relying on a contingent source of funds for that down payment and their closing costs, then they have represented through the terms of the purchase and sale agreement that they own those funds already. It's already in their possession at the time of mutual acceptance. This question is saying, how do we, as listing brokers, protect seller by making sure buyer has those funds? There's really two ways of doing it. This question asks about Form 22EF. Form 22EF is the statewide form mechanism for listing brokers to protect sellers in this regard. Listing broker might require or suggest to seller that seller require that buyer include a Form 22EF in their offer accounting for non-contingent funds. There's a whole nother discussion talking about how you use Form 22EF to account for contingent funds. We're not talking about that at all in this video. In this video, we're only talking about how you would use Form 22EF to account for non-contingent funds. For example, the down payment, the closing costs. You would mark the box for non-contingent funds, and then buyer has 3 days following mutual acceptance to provide proof that buyer owns those funds, meaning the buyer has those funds in a U.S. financial institution in an account in buyer's name. That's the definition of non-contingent funds. If the funds are held in any other fashion, stock market, an account in grandma's name, anything other than a U.S. financial institution in the buyer's name, then they are contingent funds and not non-contingent funds. So buyer has 3 days to prove that buyer has non-contingent funds sufficient to close the transaction in addition to whatever contingent funds buyer has disclosed. For example, the financing that buyer has identified in their financing contingency. That's one way of doing it, the Form 22EF. The only hesitation in using Form 22EF for that purpose is that seller's going to have their house off the market potentially for 3 days before they realize that buyer doesn't in fact have the non-contingent funds that buyer said that they had. So many listing brokers, instead of requiring the inclusion of Form 22EF in a transaction, will simply require that a buyer provide, at the time they make their offer, they provide proof of the non-contingent funds necessary to close the transaction. That could be a bank statement with their account number redacted. It could be a letter from a bank president or a private banker stating that the buyer has those funds sufficient to close the transaction. However, buyer proves it if they provide that information, not as part of their offer, but at the same time as they make their offer, 2 different PDFs, then that might even be a little bit better than the 22EF. But however you're going to do it, listing brokers, the point of this question is really well founded. You are held to the standard of care of a lawyer when you prepare a purchase and sale agreement. And as the seller's representative, helping the seller take no action that's adverse or detrimental to the seller's interest in the transaction, listing brokers make sure that you are properly advising them to seek proof that buyer has the non-contingent funds the buyer needs to close the transaction. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington REALTORS member.